Welcome to Employment Law This Week. I'm George Whipple. Our top story, reliance on salary history is not always an equal pay violation, says the Ninth Circuit. A California federal court had granted summary judgment to a female employee of Fresno County, ruling that an employer could not defeat an Equal Pay Act claim by pointing to prior salary history alone. The court reasoned that allowing such a defense would perpetuate discriminatory wage differences. The Ninth Circuit reversed, holding that salary history could be relied upon if it furthers a legitimate business policy and is used reasonably. The circuit remanded the case, directing the lower court to review Fresno County's policy based on this standard. Melissa Stannard has more on the possible impact of this ruling.
It might cause these states to take a step back and look at whether a flat prohibition on the use of prior salary is the way to go, or whether there are certain exceptions that can come into play. The other way that this can go is this can actually go to the Supreme Court. And the Ninth Circuit specifically noted that there is a split right now where some circuits are finding you can never, ever rely only on prior salary, and others are finding that you can rely on it, you just have to rely on it carefully. It's very possible that the Supreme Court picks this up and ultimately decides once and for all.
A California employer's refusal to allow an at-will employee to rescind her resignation is not actionable, and appellate court rules. An employee claimed that she was in an altered state due to a temporary disability when she resigned from her position at a California medical group. The employee attempted to rescind the resignation, and the employer refused. The employee then sued, claiming that the refusal was disability discrimination. The appeals court upheld summary judgment for the employer. Among other findings, the court held that because the employee was at will and was not constructively discharged, the employer's refusal to accept the reversal was not an adverse employment action. Are Facebook photos cause for termination? In this case, maybe not. An employee took an extended leave after surgery at his doctor's recommendation. While on vacation during leave, he posted Facebook photos of himself swimming in the ocean. Upon returning to work, he was terminated. The employee sued, claiming that he was fired in retaliation for taking an extended leave. The 11th Circuit held that the employer failed to show a non-retaliatory motive for the termination, in large part because the company gave inconsistent and contradictory reasons for its decision. Thus, the claim can proceed. OSHA withdraws its memo allowing union representatives to join inspections. In 2013, the agency released the so-called Fairfax Memo, which allowed union representatives to participate in OSHA safety inspections at non-union workplaces. The National Federation of Independent Business filed suit, claiming the memo was inconsistent with both the Occupational Safety and Health Act and its underlying regulations. In response to OSHA rescinding the Fairfax Memo, the NFIB has voluntarily withdrawn its lawsuit. Last week, the House passed the Working Families Flexibility Act, which would allow employers to offer workers paid time off for overtime instead of cash. The bill will now move on to the Senate, where it's expected to face significant hurdles. We'll update you as this story develops. Now it's time for our tip of the week. Monica Fiorentini, an HR consultant, is here with some advice on best HR practices for the future workforce.
So you may have noticed that millennials and Gen Xers are comprising more and more of today's workforce. There are certain HR strategies that we can implement to keep up with the demand of this evolving demographic in the workplace. It's really important for managers to have a one-on-one relationship with their employee so they can best understand their priorities and their needs, and also really understand what makes that employee tick. So I like to do regular, informal, frequent check-ins with my employees, like a walk and talk. Managers are probably going to notice that millennials and Gen Xers, they want to be more involved. They want to be more included in the decision-making process in the organization. And so it's great to accommodate this, but we have to be real mindful that we're also maintaining the hierarchy in the organization.
Thanks, Monica. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.